Learn will focus on the very significant changes to the New York State long-term community-based Medicaid program. So at the start, let's define exactly what care we're focusing on today. Today's presentation will focus on the care you can receive through Medicaid at home. That's why we call it community-based care. This presentation will not touch on care in the nursing home setting. We do have resources on our website if you're looking for more information on nursing home care. And the reason that I delineate that is because the rules for qualifying for community-based care in New York are very different than they would be for qualifying for nursing home care. So it's important to note that what we discussed today is limited to community-based applications. So at the law firm, we handle many community-based applications, and our attorneys are very experienced in working with our clients to assure their eligibility for the Medicaid program. Medicaid services in New York are what we call a needs-based program, and that means that you must meet certain eligibility criteria in order to be eligible for Medicaid. This is different from your Medicare insurance, which senior citizens receive after the age of 65. That is not a needs-based program. You are entitled to those services once you reach the age of 65, if you paid into the Social Security system, and if you're a disabled adult. Medicaid is the only provider of long-term care insurance if you do not carry a private insurance program for long-term care. And long-term care insurance can come to us in a number of ways. There's a New York State long-term care insurance program, which clients may have availed themselves of earlier in life. You could also hold a private long-term care policy through a company like MetLife or John Hancock. Those would be the preferable options for clients who are looking for very expanded coverage. If you did not purchase one of those types of plans and you find yourself in need of long-term care, Medicaid community-based services is usually the most accessible program. Now, the reason that we've had a number of these webinar, lunch and learn type settings is that the rules for qualifying for community-based care in New York substantially changed last year in the governor's 2020 budget proposal. Though the changes have not yet taken place, we know that the imposition of new rules is imminent. And the only way to assure that our clients can still access this program is to encourage everybody to consider as soon as possible what their estate plan will look like. So we're going to talk through some of those options today and discuss exactly what the changes mean for you as clients. So as I mentioned, the changes were implemented in last year's budget. They were slated to take effect October 1st, 2020. That deadline was pushed into 2021. Was at one point April 1st. It looks like those deadlines will be pushed to July 1st, 2021, but will be pushed again if it seems like we are still in a COVID state of emergency. And that's because the Department of Health is still working to implement all of the rule changes that will be necessary in order to institute a new program. Prior to the change in the law, in New York State, a person could have assets that exceeded the Medicaid threshold. And for 2021, the Medicaid threshold is $15,900. I'm just going to ask everyone to mute themselves. I'm just going to go ahead and mute everybody. Okay, I hope that's a little bit better. Okay, great. So in 2021, the resource threshold for Medicaid qualification is $15,900. So in 2020 and through this period, if a person had more than $15,900 in cash or liquid assets or retirement assets or different CDs, brokerage accounts, et cetera, They could move those assets in the current month. So we're in February, could move the assets out of their name in February and qualify the very next month in March for community-based care. And New York State had long been considered one of the most generous states with regard to community-based services. Our neighboring states like New Jersey and Pennsylvania are far less generous, and there are long qualification periods to receive care at home. Due to a number of different factors, not the least of which was the ballooning costs of providing this kind of care in New York, the governor passed legislation which implements a look-back period for community-based care. And what we often refer to as a penalty period or a look-back period, you might have heard associated with nursing home care. New York has long had a 60-month look-back period for care in a facility. Now, New York is implementing a 30-month look-back for care at home. And this means that the transfer I just gave you an example of in February, if we were in, let's say it's February 2022, your transfer of assets in February would cause a penalty period to be initiated in March. And penalty period is the term used by Medicaid and the Department of Health to say that you are not eligible. There will be a period during which your eligibility will be denied, meaning that you would have to find another way to fund your care during the period of your ineligibility. And the ineligibility period is a mathematical equation. It's determined by how much you transferred out of your name divided by the regional rate for care in your county. So where you reside will in some ways affect how long your penalty period will be. And regional rates vary greatly. For our clients who live upstate, the regional rates are less. For our clients who live in the 5 boroughs or downstate or on Long Island, the regional rates are higher. The cost of care, the further you come downstate, increases. So for those with higher regional rates, you actually will have probably a shorter penalty period. But how long you will have to basically sit out Medicaid eligibility will depend on, did you transfer $40,000 out of your name, or did you transfer $100,000 out of your name? So the reason that this presentation is so urgent is that our clients used to be able to wait until they were certain that they needed care at home. And care at home can look different for different clients. For some, it's issues with ambulation or safely walking around their home. For some, it's more complex. They need total care, getting in and out of bed, bathing and dressing, meal preparation and shopping. And community care can cover all of the things I just mentioned. But we used to advise even some clients that they could wait until they knew that that care was imminent. That's no longer our recommendation, because it could mean that you get stuck in a look back period, which could cause you to have to carry the cost of care at home for many months. So now we're talking about more extended look at what your estate planning can be. And if you've listened to any of our presentations in the past, and I see many familiar names here on the participants page, you will know that we have long advocated for the use of different tools, including the Medicaid Asset Protection Trust. So let's talk briefly before we get into the trust about estate planning generally. It's our recommendation as experienced estate planning and elder law attorneys that every client needs a very well thought out estate plan. Your estate plan should always include advance directives, power of attorney and healthcare proxy, a will, and some other supportive documents that we prepare at our firm. For some clients, a second level of estate planning, like a Medicaid Asset Protection Trust, is appropriate. So, what is a Medicaid Asset Protection Trust? Let's talk about that first. The Medicaid Asset Protection Trust is a vehicle through which you can transfer assets, and after a certain period of time, based on the date of transfer, your assets will be protected from Medicaid look-back period, from any kind of lawsuit relating to bills, nursing home bills, hospital bills, etc. You need to have, when you set up a Medicaid Asset Protection Trust, you as the person who creates it need to name a trustee. and it cannot be yourself. So some of you may have heard or received advice relating to a revocable trust, where you can be both the creator of the trust and the trustee. That's not the trust that we're talking about today. A revocable trust will not protect you or shield you from Medicaid penalty period. You must utilize a type of trust where you do not remain in control of the assets that go into the trust. So when you, as the creator, also known as the grantor, create a Medicaid asset protection trust, you must name a trustee. It could be more than one person to manage the assets on your behalf for the duration of your lifetime. Sometimes we call these income-only trusts because generally the provisions in the trust will say you are entitled to income only for the remainder of the life of the trust and for all of the assets that you include. And the trust can hold real property, it can hold cash accounts, brokerage accounts, it can even hold, in certain circumstances, CDs. And that account will be managed by your trustee, and they would make payments from the trust for different expenses relating to assets that are held within the trust. If you do the planning with enough time and you move assets into this kind of protection trust, when you apply for Medicaid, whether it be for community-based or nursing home care, it is entirely possible that any assets that are included in the trust will be disregarded by Medicaid, and your eligibility will be able to be established quickly. Whether or not that happens depends on how long ago you transferred assets into the trust before you applied for Medicaid. So in the examples we're talking about for community-based care, our advice at the current time is, if you are a person who has a piece of real property you intend to hold for a significant period of time, or if you have brokerage accounts you're holding just for the purposes of retirement, or cash accounts, savings accounts, etc., setting up a Medicaid asset protection trust, even before you can envision that you need care, is the most ideal way to assure that you can access the program when you need it. We can no longer say to clients, well, even if you need something on the eve of, immediately after an illness, we can qualify you. That promise is no longer true. And elder law and estate planning attorneys throughout New York State have been encouraging clients to rethink the way that they approach their estate planning based on the new rules. The new rules also implement some other changes relating to how care is provided. We're not going to focus on that as much today, but our website has a number of articles and previously recorded material from our YouTube channel that can address the other changes that Medicaid implemented with regard to how a person goes about qualifying for care. When you submit your application for Medicaid, Medicaid is determining your eligibility on two factors: financial eligibility, which is what we're talking about today, and whether or not you meet the care standard that Medicaid has set out for eligibility. And the care standard, there were some changes to that part of the program as well, and you can read about those on our website. So one of the other things to be concerned about is what happens if you haven't transferred assets in enough time. What happens if you get caught in what we call the penalty period? So the Department of Health still has yet to finalize all of the new regulations on how the penalty period will be assessed with regard to community-based care. However, we know from the nursing home cases that the penalty period will usually be assessed as of the date that you need care. So we cannot apply for community-based care long before you need it. You will need to have, established your need for care in order for the penalty period to begin to run. Now, the good news is, unlike a nursing home, where if you pay privately, the cost of care is generally, depending on where you are in the state, about $14,000 or $15,000 a month, home care services are far less expensive. So if you have to wait out the program for 6 months, it will likely be far more affordable than if you needed to wait out the penalty period in a nursing facility. So we hope that even those clients who do get caught in the look back period, we will be able to help assist with locating affordable community-based care through a number of different avenues, whether it's a managed long-term care provider, an informal caregiver arrangement. There could be a number of different ways that support at home is established prior to using a managed long-term care through Medicaid. You can also, of course, privately pay for home care during the period in which you are not eligible. Now, the rules that we talked about regarding the transfer of assets, the one exception to the rule that is essential for clients to know is if you have a spouse, you can transfer all assets to your spouse and be eligible the next month. That part of the legislation remains. It has been long rumored that the state is looking to eliminate the spousal transfer, the exemption for spouses, because the state needs the influx of money in order to continue to administer the program. However, at the current time in the 2020 budget and also in this upcoming 2021 budget, the spousal refusal provisions remain. So if you are married and you need care in the following month, you may still transfer your assets to what we call the well spouse, the spouse who doesn't need care. And that person can sign a refusal, meaning they refuse to make the assets available, and that will trigger Medicaid eligibility. What's important to understand, though, is for the spouse left holding the assets, I often refer to it in my consultation as hot potato. The spouse left holding the hot potato, if that person should need care, they now are holding the assets and can't transfer to their spouse because that person is already using the Medicaid program, and now cannot make a transfer to anyone else without triggering a penalty period, unless, with a few exceptions, you have a disabled child. So it is imperative that even if we have a spousal arrangement, even if we have clients who are married and one person seems entirely well and the other person seems like they may need care, we would still engage in the discussion of the use of something like a Medicaid Asset Protection Trust to assure that both spouses are covered. And there are various ways that we accomplish that when we do our planning. So I hope that this has been informative for you with regard to the changes that are coming. Again, the implementation date is slated for July 1st. Whether or not those changes will actually be implemented on July 1st has yet to be known. As again, the date has been pushed back a number of times. Clearly, the state is still managing the COVID crisis and the impact that has had on care. I will say that the majority of our clients, and I'm sure many of you listening today, would prefer to be cared for at home. And that is the state's preference. It's much less expensive for the state to care for you at home than in any kind of long-term care facility. So if you are interested in assuring that you can remain in your home and receive appropriate care there, then this type of advanced planning is essential. Additionally, I will note that we often get questions from clients about assisted living facilities. Assisted living facilities in New York, for the most part, are not covered by the Medicaid program, no matter what you've done to make yourself financially eligible. Assisted living programs in New York are not considered medical in nature, and so Medicaid, with very few exceptions, will not cover rent in those facilities. However, we do have a number of clients who pay the rent privately and then access Medicaid community-based program for care within the facility. So home attendant services can be provided at an assisted living through the Medicaid program for no additional cost. So those who have looked at assisted livings likely know many of the bigger companies like the Atrias and the Bristols, they might have in-house staff, but that use of care is very expensive. You can apply if the facility approves for outside care. You can apply to the community-based program to provide one-on-one support for yourself or a family member in the assisted living facility. But again, you would need to meet the very strict income and resource requirements of Medicaid, and you would have had to have thought ahead regarding the transfer of assets or be subject to the penalty period. I only mention this because I know assisted livings have become a good resource for many clients who want to stay in more of a traditional apartment or living arrangement, but don't necessarily know what the coverage would be for that. Unless you have a private long-term care policy or one through the New York State Partnership Program, you likely would not have your rent covered by Medicaid or any other medical coverage. So I see a few questions popping up in the chat, and let me see if I can get to them. Okay. What if you need part-time home-based care? Does this qualify until you reach the point of needing full-time care? So the answer to that question is no. Medicaid, when you walk into the Medicaid office with your application, the financial qualifications have nothing to do with how much care you need. They're not even considering care until the financial qualifications have been completed. So whether you need 5 hours of care a day or 12 hours of care a day, your eligibility will not be based on your care need. It will be based purely on whether you meet the income and resource standards set by Medicaid and whether you can prove that you transferred assets with enough time that you don't fall into a penalty period. So that's a great question. And it would seem intuitive that your hours of care could impact your eligibility, but that is not the case. So the next question, does the change impact respite for young people living at home? No, so there are certain exceptions to the community-based changes. Some people access respite through their Medicare insurance or other private health insurance. It's not frequent that Medicaid pays for respite care in any event, but for those people who are accessing care through some waiver programs, through OPWDD, for example, these community-based changes don't often apply. It's also pretty typical that young people would not have had the financial resources that someone of the age of 65 or older might have. So even if there had been an imposition of a penalty period, the period would likely be short. I see another question here. Can you describe the use of loan to deplete assets and how it's paid back to the nursing home? Okay, so this question seems to be aimed toward the nursing home side of qualifications. As I mentioned at the start, it's not the subject of today. What I'll briefly say is that there are a number of what we would call emergency planning tools that can be used if you find yourself caught in a look-back period. One of those tools is often called a promissory note. Some people refer to it as a gift and loan strategy. That is a strategy through which a calculation is made regarding the amount of assets that need to be transferred and how you can use a Medicaid planning tool to make yourself eligible and still preserve some of the money that belong to the applicant. It's somewhat of a complicated explanation. It will, in some senses, it could, in some senses, apply to community-based care if the applicant has a great deal of money in their name and is attempting to try to qualify for home care services. But this question seems to be more of a specific case. It would be difficult for me to answer this fully during the presentation. The next question, if the assets income go into a Medicaid asset protection trust, it is irrevocable, correct? So the short answer to that question is yes. By its nature, an irrevocable trust is not revocable by the creator. And there are certain qualifications that the trust must meet in order to be considered an appropriate Medicaid asset protection trust. So when you meet with a qualified estate planning or elder law attorney, you will be assured that the trust they create meets all of the requirements of the social services law and the estate powers and trust law that would assure that the trust created on your behalf is appropriate. One of the terms that must be met is it must be irrevocable to the grantor, or it's not considered a Medicaid asset protection trust. It could be trust used for a different purpose. Does Social Security count as an asset? So that's a good question. When we look at financial qualifications for Medicaid, we look at two items. We look at resources, which are the type I've mentioned before, brokerage account, bank account, and we look at income. How much do you receive on a monthly or annual basis that is qualified as income? Social Security is considered income, so we wouldn't call it an asset. It doesn't belong on the resource side of the equation. If, for example, you get a pretty large Social Security check every month and you only use half of it and you put the other half into a savings account and that accumulates over time, sure, that is an asset that Medicaid could look at. But the monthly distribution of your Social Security will be considered on the income side of the calculation. And we must meet certain income requirements in order to have our clients become eligible for either community-based or nursing home plan. And we at Littman Krooks are very skilled in working with clients to help them understand what the income requirements are and how best to deal with income that might exceed the Medicaid limit. A question here, what is the downside to a Medicaid Asset Protection Trust? So some clients find that the Medicaid Asset Protection Trust is restrictive. And what I mean by that is that many individuals might not be prepared to hand over control of their assets to a third party. And that's a perfectly understandable concern, especially for those of our clients who don't have close family or friends. Handing over control to a third party can be very nerve-wracking, especially if you've always managed your own financial affairs. We have to balance those concerns, of course, against the risk of being caught in a place where you are not eligible for care. So some of the considerations may be based on how much is in your savings account, how much you have accumulated to fund your retirement. Some of that may be based on what your care needs are, how intricate will your care needs be. Some people come to us already knowing I have Parkinson's disease, so we know that they will need a substantial medical support as they move forward in their disease, and we take that into account when proposing a plan. But certainly, going through the pros and cons of these types of trust instruments is essential when working with an appropriate estate planning elder law attorney, and we encourage all of our listeners to get qualified advice before making a decision about these kinds of assets. Did the asset resource limit change for 2021? You mentioned it was $15,900 for 2020. No, it's $15,900 for 2021. So that is the number for this year. And that will be the number that applies to any Medicaid application that's submitted in the calendar year of 2021. So if anyone else has any questions, you can pop it into the chat. And I'll wait just a minute. Otherwise, again, I'll remind you that our website has a wealth of information regarding this topic and many other topics related to long-term care. And we are always available at Littman Krooks and look forward to consulting with any of our listeners today regarding their specific questions. Each client has their own personal circumstances that really warrant a good evaluation of your retirement assets, your income, your expenses, to understand the appropriate use of the tool that we talked about today. And certainly we look forward to meeting with anyone who has further questions about this program and qualifying for Medicaid. And we, encourage everybody again to think about your estate plan in greater detail to assure that you are prepared for the eventuality that you need care or support at home. And there's one last question here. So is 401k an asset or just a minimum distribution? That's a great question. Retirement accounts like a 401k or IRA accounts or traditional IRA accounts are not included in the resource side of the calculation. Whatever distributions come from those accounts are considered on the income side of the equation. So when we do the Medicaid application, we look at both resources and income. Anything that comes as a required minimum distribution, we take that number, divide it by 12, and that becomes your monthly income that's attributed to your retirement account. So we do look at all of those assets, but Medicaid will disregard the total amount sitting in the IRA. So if it's a $1.5 million IRA, that will not count against you in the $15,900 category. Medicaid will capture that resource on the income side of the equation. What is the income amount from Social Security which would disqualify you from applying for care at home? Okay, so there is no disqualifying amount for income purposes. Luckily, in New York, at the current time, those who are 65 and older who are declared disabled will be allowed to use a tool called a pooled income trust. So for most individuals, their income, the amount that exceeds the Medicaid threshold can be deposited into this kind of account and would be retained, and the client can use that money to pay bills. I say for most because depending on the amount of your income, it may not be a feasible program for the client to engage in. Some of us who have very high incomes or who receive rental income or income from a business, for example, simply may have more income than the program can really support. So it's not true of everybody, but income, we can deal with excess income. So there isn't an amount that would disqualify you in terms of the income side of the equation. If I provide an allowance to parent to help cover bills, is that an asset? That's a really complex question, and it really depends on what you mean by allowance. And we have different strategies for dealing with how to help a person continue to pay their own bills while also placing the majority of their assets into the Medicaid Asset Protection Trust. Sometimes it's as simple as a mathematical equation. How much money do you need to support yourself every month? What is your income? How much excess would you need? And we can make the decision not to put all of the assets into the trust. That's a unique decision for each client, and we make those kinds of recommendations after looking at all of the income and assets that a person has, and we weigh that against the expenses of their cost of living. Okay, great. Well, it's been my pleasure to be with you this afternoon for our Lunch and Learn on the Community-Based Medicaid program. Again, feel free to reach out to any of us at Littman Krooks if you have any additional questions. And we wish everyone a happy new year and a healthy start to 2021. And we look forward to meeting with you all soon. Thank you.